So what's a domestic asset protection trust, and what can you do to protect your assets from lawsuits? Protecting your assets against lawsuits and creditors is among the best moves you can make to keep the courts from taking what's yours. One of the many ways people gain protection that they're looking for is by using domestic asset protection trusts, or DAPTs. But how exactly do DAPTs work? Asset Protection Planners has the answers because our firm has been setting up domestic and offshore asset protection trusts for over 3 decades. And in that time, we've learned the most important things that you need to know about DAPTs, and we've put it all in this comprehensive guide. Please subscribe if you haven't, and while you're doing that, here's what's in this video. What is a domestic asset protection trust? States that allow domestic asset protection trusts. Who needs one? Benefits, disadvantages, when to set one up, domestic asset protection trust tips, and domestic versus offshore. Which one is better? So what is a domestic asset protection trust? A domestic asset protection trust, also known as a United States Asset Protection Trust, is a type of irrevocable trust available in certain states. It's often used for estate planning and mostly protecting assets from creditors and legal threats. DAPTs are unique in that they're self-settled trusts, and this means that the settlor, the person creating the trust, can list themselves as a beneficiary and receive distributions from the trust without impacting its asset protection capabilities. However, while the settlor can be a beneficiary, they are not allowed to be the sole trustee because that would kill the asset protection. So what we do is we set up an LLC, we put it inside the trust, we make the client the initial manager and the signatory on the bank account. And then when under legal attack, the trustee company can step in as LLC manager to protect you, because if you state LLC manager, the courts could force you to release the funds. And since you are simply changing positions within the LLC and not moving assets around, the courts would have a hard time nailing you or fraudulent transfer of assets away from the person who won the lawsuit against you. And unlike offshore asset protection trusts, DAPTs can be operated by a trustee in the same jurisdiction as the settlor, provided they place the trust in their home state. Now, this may give the grantor peace of mind, as they can appoint a trustee who is familiar to them and lives nearby. However, it's worth noting that the trustee must be a resident of the state where the trust is created, and some or all of the trust administration activities must occur there too. Plus, it creates a major drawback in that the trust and the trustee are both subject to U.S. court orders, unlike offshore trusts and trustees. As an aside, we do have an alternative called the trigger trust, which is a domestic trust that can turn into an offshore trust if you need more powerful protection. Now, domestic asset protection trusts were created as a marketing tool to dissuade people from using foreign asset protection trusts. States were concerned about the number of assets leaving their jurisdiction and felt compelled to create an alternative for their citizens. Before Alaska created its DAPT laws in 1997, most people use offshore trusts to protect their assets. Today, 17 states offer DAPTs, and this includes Alaska, South Dakota, Delaware, Wyoming, and Nevada. These type of trusts have steadily gained popularity since they were introduced thanks to the ease of setup, proximity to the U.S.-based settlers, and ease of use in estate planning. So let's talk more about states that allow domestic asset protection trusts. As we said, states began offering domestic asset protection trusts in 1997 when Alaska and Delaware introduced their DAPT provisions. And as of this video, DAPTs are only available in the following 17 states: Alaska, Delaware, Hawaii, Michigan, Mississippi, Missouri, Nevada, New Hampshire, Ohio, Oklahoma, Rhode Island, South Dakota, Tennessee, and Utah, plus Virginia, West Virginia, and Wyoming. Now, it's better to establish a DAPT in a state where you live if possible, but you notice many of these states have small populations. So more likely than not, you don't live in one of those states. But if you do, setting it up in the state where you live will help you avoid situations where the full faith and credit clause of the United States Constitution comes into play. This clause requires each state to recognize other states' judgments without going through a retrial. When you live in a state with unfavorable trust laws, your DAPT security could be in jeopardy, even if that DAPT was founded in a very trust-friendly state. So if you live in California, Texas, or Florida and have a Nevada trust, your local courts can disregard the trust. So your judge says, you're here, your assets are here, hand them over. I mean, check out the case law. If the trustee is U.S. based, a U.S. judge has jurisdiction over the trustee and can compel them to hand over your money, unlike their offshore counterparts. When you choose a state to establish your trust, you know that not all DAPT laws are created equal. Now, when you choose a state to establish your trust, know that not all state DAPT laws are created equal. The protections offered by DAPTs vary from state to state. All of the states that offer irrevocable asset protection trust statutes, Nevada and South Dakota, are renowned for having the best trust laws. But because they're stronger, that's why we set up a lot more offshore trusts for our clients than domestic trusts. Now, Nevada and South Dakota offer the shortest waiting period, 6 months if the trust is publicly declared before your assets are protected. In addition, Nevada is the only state that doesn't recognize exception creditors, which can breach the trust protection. South Dakota does list the exception of a divorcing spouse. So these two benefits allow you to set up the trust quickly, deposit your assets into it, and protect those assets against almost any type of creditor, even an ex-spouse looking for alimony if it's a Nevada trust. So who needs a DAPT? A domestic asset protection trust is best suited for those who work in professions with high lawsuit risks, such as physicians and lawyers, and these trusts are a good fit for high net worth individuals and those with public personas such as celebrities and CEOs. Now, in layman's terms, a domestic asset protection trust provides these individuals with effective ways to shelter their wealth against legal action without forcing them to place their belongings into the hands of a trustee in another country. Now, that said, with a reliable trustee, the proven track record and robust legal precedent of an offshore trust remains unmatched for asset protection. Now, the DAPT is also useful for anyone concerned about the burden of estate taxes. Trusts are not subject to the same death taxes, and as a result, many people place their assets in a trust to ensure that the inheritance they leave behind retains its maximum possible value. So let's talk about the domestic asset protection trust benefits now. Domestic asset protection trusts provide several benefits, including increased asset security and personal convenience. Now, it's worth noting that some of these benefits are only possible when the trust is set up by an experienced professional group like asset protection planners. So we'll talk about the primary advantages of DAPTs here. Availability to non-residents. Now, when creating a domestic asset protection trust, the settler is not required to establish it in their home state. They can form a trust in any state that offers a DAPT as long as their trustee lives in the state where the trust is formed. This is particularly useful for settlers living in states that do not offer DAPTs or who need more comprehensive asset protection than their home state's DAPT laws provide. Creditor claim protection. Sheltering an individual's assets from creditor claims is the principal benefit of domestic asset protection trusts. Once anything is put into the trust, several legal barriers are formed between a creditor and those assets, and in many cases, merely placing assets into a DAPT will discourage frivolous lawsuits. Divorce protections. It's best to place money and personal items into a trust before marriage to protect them during a divorce. Setting up a trust provides many of the same benefits offered by prenuptial agreements, but the problem is that prenups are penetrated every day of the week. Plus, a DAPT doesn't require the same detailed breakdown of how each asset will be divided if the couple separates. Moreover, you can establish a trust on your own, avoiding the potential relationship strain that often comes with a prenup. Because keep in mind, when setting up a prenup, you have to hire an attorney for yourself. Your spouse has to hire a separate attorney. They fight. Yours fights for giving less. Theirs fight for giving more. And it's a real romance killer. Additionally, because trusts are used for estate planning, discussions about placing assets into a trust are often less emotionally fraught than those surrounding a prenup. Greater cost barrier for lawsuits. Litigation is costly, as you know, and the complexities introduced by a trust could make the case longer and more expensive for the one suing you. Even creditors pursuing debt payments will often settle out of court for a much lower amount than the debt amount owed due to the high cost of court action. No holding or transfer limits is another benefit. Just about any asset you own can be placed within a domestic asset protection trust. Virtually anything, including liquid currency, real estate, stock holdings, investment accounts, and even personal possessions can go into a DAPT. Also, because the settler can appoint themselves as a beneficiary of the trust, these assets will remain partially accessible to them. Short statute of limitations. In the world of trust, a statute of limitations means the limit on how long a creditor has to file a lawsuit to challenge an asset transfer into a trust. In most states, the DAP statute of limitations is 4 years after the transfer occurs, although some states have 2-year, 18 months, and even 6-month statute of limitations, as is the case in Nevada and South Dakota. So all these benefits have made domestic asset protection trusts a popular choice for residents of the U.S. who need to guard their wealth against creditors and legal threats. Now here's the thing. For it to actually survive the rigor of a courtroom challenge, one must have a properly drafted asset protection trust. Thus, many of the benefits are only made possible with the help of an asset protection professional. Without a professional team at your side, you could be at risk of forming the trust in a way that leaves your assets vulnerable. Now, here are some DAPT disadvantages. Now, while domestic asset protection trusts have many benefits, they're not foolproof. Certain elements of DAPTs can leave your assets unprotected against certain legal actions and various creditors. So let's talk about some drawbacks you should know before creating a DAPT. Efficacy varies based on home state. Though residents of any state can form a DAPT in another state, these trusts don't always work effectively for people who live in states that do not offer them. For example, residents of California, New York, or Texas who establish a DAPT in, say, Nevada can have their assets pursued via court order from their home state. An offshore trust may be a better option if you live in a state that does not offer domestic asset protection trusts, or even if you do, by the way, if you look at the case law. So simply put, the case law history shows that offshore trusts are simply more effective at protecting assets than domestic ones. Lack of bankruptcy protections. If the settlor files for or is forced into bankruptcy by their creditors, their trust can only protect assets that have been a part of the trust for at least 10 years. This long waiting period makes the DAPTs a poor option for those facing imminent bankruptcy. Minimal privacy. Unlike offshore trusts, which have strict confidentiality provision, DAPTs offer little or no privacy. These assets can be revealed by subpoenas and discovery orders, making it easier for creditors to go after them. After all, the trust and the trustee of a domestic trust are under the jurisdiction of the U.S. courts, susceptible to court orders. Thus, the primary drawback of the domestic asset protection trust is their susceptibility to court orders. Judges in the U.S., particularly at the federal level, can order trust assets to be confiscated regardless of what state statutes say. And if your trustee attempts to refuse the order, they can be found in contempt of court. This is a huge disadvantage when compared to offshore trusts, which are not subject to court orders from the United States. Trustee location requirements is another disadvantage. To form a domestic asset protection trust, the settlor needs to select a trustee who lives in the state where the DAPT is formed. This requirement limits their choices when picking a trustee. And more importantly, it can put them in an uncomfortable position of having a stranger legally own and manage a significant portion of their assets. Ultimately, you're looking for a trust that's virtually guaranteed to protect your assets against pressing legal threats and creditors. A domestic asset protection trust has some shortcomings, especially when compared to an offshore trust. However, DAPTs are still valuable tools that provide some protection and are excellent for estate planning. When deciding which one is right for you, weigh the disadvantages and the advantages in relation to your unique situation. Somebody watching this video may say, it sounds like he's really pushing those offshore trusts. And they'd be right. I am pushing offshore trusts, so to speak. And for one reason, they protect assets better. And keep in mind, we do set up both domestic and offshore trusts. It's just that I've seen domestic trusts penetrated by results-oriented judges, and I've never seen one of our offshore trusts penetrated, and we've set up more Cook Islands trusts than anybody on the planet. So for people wary about going offshore, that's why I invented and trademarked the Trigger Trust, which is a domestic offshore hybrid like we discussed a bit ago. Okay, when do you set up a domestic asset protection trust? Domestic asset protection trusts are most effective when they're set up before the court renders a creditor judgment. Once a DAPT is set up, the assets within it are not fully protected until the statute of limitations on an asset transfer expires. And in many cases, the statute of limitations is multiple years. If somebody sets up a DAPT just months before a lawsuit, their trust likely won't provide the asset protection they need. So establishing a trust well before legal trouble arises can also prevent the trust from being seen as a fraudulent conveyance. If someone's lawsuit and a DAPT administration happen to coincide, the court could rule it's a fraudulent transfer. And the good news is that fraudulent transfer standards are quite conservative. Most jurisdictions require a high burden of proof before they deem a trust as invalid. Still, it's always best to form a trust well in advance of this time to avoid the situation entirely. Now, once the statute of limitations ends and the trust assets can be protected from creditors, there's still some risks to keep in mind. Each state recognizes pre-existing and exception creditors, with the lone exception of Nevada, which does not recognize the latter. Exception creditors can access trust-held assets that most creditors cannot. Common examples of exception creditors include alimony and child support, claims brought by ex-spouses, and each state defines the exception creditors differently, and the definition will depend on the state's classification and public policy. So in short, the best time to set up a DAPT is well before it is needed. Making one early on helps to ensure that it will be able to protect the assets whenever the threat arises. Domestic Asset Protection Trust tips as promised. The way that your trust is set up will have a significant impact on how well it protects your assets. So to ensure that you receive the maximum protection possible, follow these tips. First of all, speak with a qualified asset protection planner to help select the right jurisdiction for you. Establish a properly drafted irrevocable trust. Select an experienced independent trustee who lives in your chosen DAPT state and should have solid references and business contacts. And that's where we come in, because we already have the relationships with the people that we have vetted. Transfer assets and/or make deposits in your DAPT state rather than the state where you live, provided that your trust is not in your home state, that is. Only place real property into your trust if the property is physically located within the state where the DAPT was created. Make compliant transfers to your trust based on the laws of your home state and the state where your trust is formed. Make sure your trustee has absolute discretion over trust distributions to the settlor. Ensure the trust settlor holds no direct interest in the trust assets, and check your state laws on property transfer and divorce, especially if the trust was established while you're still married. Next, you'll want to determine the DAPT state's taxation requirements for non-resident trust settlers and adhere by all the tax regulations. So by following the tips that I just talked about, you can rest assured that your domestic asset protection trust will provide you the maximum protection that it can and help provide a defense against the threats to your wealth. In fact, we help our clients continuously review any updates to DAPT laws within the state where your trust is formed to ensure that you're keeping the trust compliant. And if you choose to work with a professional group, they can manage a portion of your trust maintenance for you. Strengthen your domestic asset protection trust with professional help. Setting up a domestic trust for asset protection purposes is an impressive first step to building your financial security. However, working with a professional can help you create the trust with even more robust protections. One way a professional can improve a DAPT's efficacy is by charging order protected entities. A charging order protected entity is, for example, an LLC, a limited liability company, an LP, limited partnership. If a creditor attempts to claim your assets, they'll find that the LLC or LP owns them. And that's a reason why we put one of these entities inside of the trust. And this adds another layer of protection to your assets if the DAPT is disregarded for one reason or another. An even stronger domestic trust that professionals can help set up is a trigger trust. A trigger trust is initially established as a domestic asset protection trust. However, when legal troubles may threaten trust assets, your trustee can enact the trigger provision, and this action turns the domestic trust into an offshore trust located outside of your court's jurisdiction. So domestic versus offshore. Which asset protection trust is better? Whereas a domestic asset protection trust may offer a significant step forward in asset protection within the U.S., offshore trusts remain a superior option for those seeking maximum protection from lawsuits, divorce, and judgment. Those trusts are governed by foreign laws that often provide far more robust protection for trust assets. Offshore jurisdictions typically have a strong legal framework designed to shield assets from creditors or other claimants. These jurisdictions often have strict privacy laws that make it difficult for creditors to even locate trust assets. Additionally, many offshore trust jurisdictions offer strong protections against fraudulent transfers, meaning that creditors may have a harder time challenging the trust validity. And more importantly, offshore jurisdictions do not have to adhere to court rulings that happen outside of the court system. Even if a judgment is obtained in a domestic court, it may be virtually unenforceable against offshore trust assets. And as you can ascertain from our discussion, DAPTs don't offer quite the same level of protection as offshore trusts. However, they're cheaper, they may be more convenient to set up, and if you have few creditors and are unlikely to be sued, at DAPT may be right for you. So feel free to schedule a free consultation to see if a domestic asset protection trust is right for you. Securing your assets against lawsuits, divorce, and creditors is more important than ever. Lawsuits are on the rise, and your chances of being sued increase with each passing year, especially if you work in a high-risk profession. So the right asset protection strategy can help you protect your wealth and livelihood. So go ahead and visit assetprotectionplanners.com today. You can fill out a free consultation form. You can talk with one of our attorneys or consultants, and you can see which domestic asset protection trust or offshore trust can provide you the security that you need. We'll see you next time. This is The Business Guy.